It's Monday the 13th. This is the House Judiciary Committee. We're having a voting session. 3 bills are being withdrawn: House Bill 533, 773, and 482. It's a motion for an unfavorable for the withdrawn. Any discussion about the unfavorable withdrawn? Seeing none, all in favor of the unfavorable withdrawn on those 3 bills, say aye. Aye. Opposed, nay. Those bills are unfavorable and withdrawn. Now, we're going to go to House Bill 186. This is from the Chair of Appropriations. It was a joint bill. And could I just have, Lauren, are you here? Yeah. Can you just tell, just want to make sure we know what the bill does, and I know there's an amendment here, so what the bill does is with the amendment.
Okay, so my understanding, and appropriations staff sent me a really helpful little summary saying that the bill now basically just ensures that victim services funding through the Victims of Crime Act, or VOCA, remains close to previous year levels by allowing the state to cover any gap in funding. So in reality, this means that the $25 million or so from federal sources comes in, but there's $35 million remaining, so the state takes care of that. And the previous and current governors have put $35 million in general funding into VOCA, so the gap is expected to be filled already, but this bill just protects that funding in case they don't. The amendments, Amendment number 1 clarifies the rules concerning the usage of VOCA funds and prohibits their use for capital projects. And Amendment number 2 clarifies the total aggregate funding amount and the reporting requirements for the agency.
Let's do this. Could I have a motion on the amendments? There's a motion for amendments. Is there a second? Motion and second. All right, so we're on discussion on the amendments. Are there further questions about the amendments? Seeing none, all in favor of the amendments, please raise your hands. Anybody opposed? Amendments are adopted. We're now on the bill as amended. Is there a motion on the bill as amended? Favorable is the second. All right. So we're now on the bill as amended. Are there further questions about the bill as amended? Seeing none. Okay. The Vice Chair. Yes. Yes. Munoz? Yes. Yes. Crutchfield? Yes. Yes. Cardin? Yes. Yes. Bartlett? Yes. Yes. Embry? Yes. Yes. Costure? Yes. Yes. Tolles? Yes. Schmidt? Yes. Yes. Boucher? Yes. Yes. Phillips? Yes. Yes. Tomlinson? Yes. Erican? Yes. Yes. Taylor? Yes. Yes. Simpson? Yes. Yes. Grammer? Yes. Yes. Young is excused. Valentine? Yes. Yes. Conaway? Yes. Yes. Kaufman? Yes, and add. Yes, we can add. And yes, so Kaufman, yes, and an add-on, and Delegate Williams? Yes. Yes. All right. That's unanimous. We're going to go ahead now. Well, let's learn about trees. House Bill 612. There are amendments. Whose bill is this? This is Claire's bill. All right. Can you tell us what the bill does, please, and what the amendments do?
This bill is jointly assigned with ENT, and they're the primary committee. The bill makes various changes to provisions governing the licensing of tree experts relating to penalties for engaging in the work or business of a tree expert without a license, the ability of a person to physically engage in treatment, care, or removal of trees for compensation under another person's tree expert license, and insurance requirements applicable to a licensed tree expert. And the amendments that were adopted by the other committee authorize a person to work under a tree expert's license if the person employs a licensed tree expert who can provide oversight, is employed by a company that employs a licensed tree expert who can provide oversight, or is a licensed tree expert.
Okay, there is an amendment that was put onto the bill in the Environment and Transportation Committee. Can I have a let's do this. Let's take a motion on the amendment and then go to the amendment, and then we can talk about the amendment and the bill. So can I have a motion on the amendment? Motion for a favorable and a second. All right, so we're on the amendment, but there are questions, so let's go to Delegate Schmidt.
I appreciate you bringing in the amendment. There was a lot of questions when we were there in ENC about that amendment. Is there a way to get a copy of that? There was a lengthy discussion about that. It was a long hearing on this bill for that very reason. And the reason I want to bring it up to the committee, I believe the top 4 companies in the state of Maryland, which do about 70% of the business in the state, would have been affected by this bill. So the amendment may correct that, and I don't know what the procedure would be to talk to maybe ENT or the experts about that, but the amendment may correct that from the top 4 companies. If anybody was there with me that wants to talk about that.
I did. Oh, Delegate Schmidt, I guess I'm just curious, how would they be affected, the top 4 companies in the state? Because I thought the bill just had to deal with tree experts who are unlicensed. And so I would assume if they're one of the top companies in the state, they're all licensed, bonded, insured, all that other fun stuff.
It was my understanding, I think the amendment might correct that, but it was based on those 4 companies not being Maryland-based companies, so they may have not had a tree expert. It was asking for them to be the tree experts and to have the oversight, right? So let's say they were a Pennsylvania-based company. I think Asplin was the example that was brought up in the hearing. They have a president that's in Pennsylvania, yet they're doing a majority of their work here in Maryland, so it would have to fall under his license, basically, or her
So
license.
even though they do a lot of work here in Maryland, you're saying they're not licensed here in Maryland?
I believe they are, but I think it was a designation on who the licensee was, actually on the job, actually responsible. So I think that was where there was a lot of gray area with who the licensee would be.
Got it,
If that made sense. Who, was Charlotte there with me that day? Okay.
Is it on? Yeah. Yeah, that's correct, because it's based on, the contracts are based on the contractor is the company itself. So that's why it's a concern that the individual company owner, quote unquote, doesn't have a license.
Well, the bill as introduced, one of the provisions of the bill was that a person may not engage in the work of treatment, care, or removal of trees for compensation under a tree expert's license unless the person is employed by the licensed tree expert. That was the original language of the bill. And then the amendment inserted the word physically. A person may not physically engage in the work of treatment, care, removal of trees, and added 3 options: that unless you're employed by a tree expert, employs a licensed tree expert who can provide oversight, is employed by a company that employs a licensed tree expert who can provide oversight, or is a licensed tree expert. So the original, the fiscal note noted that in the original bill, it could have a meaningful impact on small businesses because of the elimination of the option for a business and its employees to operate under the supervision of a licensed tree expert that is not the owner of the business. But the amendments seem to authorize that.
did you want to? Delegate Tomlinson?
Yeah, I know a little bit about this. So especially with the amendment, which I don't think, yeah, I know I had not seen it till just a second. I mean, this bill looks like it's pretty much what they're trying to stop are folks who go out there and are going out there and under somebody else's license, and they're going out there and doing tree work. Anybody who's got like a legit real company, I'm pretty confident they'll be all right under this bill. This is really to stop basically just complete people with no, and I know that there's a lot of people who do this, people who have no insurance, no actual license, and they're just kind of using the license number of somebody who is actually certified. That's what I gather, especially with the amendments. I mean, I don't think, Delegate Schmidt, I know we were talking, I don't think with the amendments this would affect affect those large companies you were just talking about. I think they would probably still be fine.
Okay, first of all, just as a mentioning, for these bills that are jointly assigned between us and other committees, we can't take, people seeking to be added on as co-sponsors because they'd have to go back to the previous committee, so we can't do that. I heard the motion for the previous question, and I think, I feel like that there are still some questions that the committee has, so I'm just going to hold on to this for a day. We can talk about it a little bit more, and we'll come back to this one tomorrow. Let's go to House Bill 34. And this is also between us and Environment and Transportation. This is Holly. Can you, where are you? Okay. Yeah. Talk about what the bill does and what it, well, and what the amendments do as well.
Okay, so as Chair said, this bill is joint with E&T. The bill generally requires the district court within 60 days after the final resolution of a failure to pay rent proceeding that did not result in a judgment of possession, the district courts shall seal or should shield all related court records. The bill authorizes a court to shield all court records relating to a failure to pay rent proceeding that results in a judgment of possession on a motion of a tenant if specified requirements are met. And in general, the bill prohibits a landlord from increasing rent solely because a judgment was entered against a tenant in a failure to pay rent actions. The amendments from E&T provided for the shielding rather than the sealing, which is what was in the bill before, and alters the standard to shield certain records and open shielded records. It provides if a judgment for possession is entered in a proceeding in which the tenant asserted a rent escrow as a defense, that the district court may shield only the court records related to the judgment for possession. The amendments provide that in order to shield court records may not affect an action in which an appeal is pending, and the bill is prospective only. I have a little note here. So E&T worked with the Maryland Judiciary, and that amendments addressed their concerns. They also worked with landlord and tenant advocates on both sides, and that includes the other amendments with regards to the escrow language.
There's a motion for the amendments. Is there a second? All right, we're on the amendments. Any questions or discussion about the amendments or the bill as has been described? Vice Chair.
So does anyone oppose the bill with these amendments on?
I think
No. Okay.
So the vote in Environment and Transportation Committee was 17-6.
With no one opposing
Those opposing the bill included delegates Jacobs, Otto, Siliberti, Nawrocki, Morgan, and Baker. Okay. All right. Further questions on the amendments? Seeing none, all in favor of the amendments to this bill, please raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Anybody opposed? Seeing none, the amendments are adopted. So now we're on the bill as amended. There's a motion for a favorable and a second. Any further discussion on the bill as amended? Delegate Schmidt.
Is there a way to get a copy of that amendment as well? Because I think that could answer the ceiling versus the shielding would be something that I would want to look at. And then also with the escrow, when a tenant pays into escrow, it doesn't become a failure to pay rent. And there wouldn't be a judgment entered. So I think some of the language is a little.
They can assert the rent escrow as a defense in the failure to pay. So, and then Dylan should have emailed the reprint and also the amendments for this one. But yes, so that's with regards to the judgment for possession. And if they've asserted the rent escrow as the defense, the district court may versus the shall shield the record.
So does that become the judge's discretion then? Or how does that work?
That would be at the discretion of the district court, yes, in those situations. And it's only the court records related to the judgment for possession.
Further questions?
I think my next question would be, I'm sorry.
No, please.
The solely, we bring up the word solely quite a bit in these landlord tenants. So solely, it becomes a challenge for me sometimes because I don't want the landlord to come up with a different reason, right? Because in these failure to pay rent cases, you have a lease. You wouldn't increase the rental percentage if you have a lease. That would be a breach of lease. So I don't want these landlords to then come up with a different reason. So that's where sometimes the language of these bills, without having ample time to kind of review through it.
Here's the amendments.
You have the amendments.
So you have, it starts here.
Delegate Card.
Mr. Chair, I would just say that the language that was agreed upon by all parties is that the landlord cannot increase the rent solely based on a judgment being entered. So there could be other factors, and the judgment can be part of it, but that seems to be a reasonable language. That's all I would say on that, in that regard, for what you just brought up.
Delegate Grammer?
Yeah, and just to add comment to the discussion, one could argue, well, my rent was increased, and I believe it was solely based on this reason. You know, the landlord says, well, no, it didn't have anything to do with that at all. And in these kind of cases, like, how do you prove or disprove any of that? And it becomes this litigious, contentious situation. I just don't think these kind of bills make much sense, and they tend to be an infringement on property rights. So that's why I'm a no here.
Any further questions or statements about the bill as amended? Seeing none, we're going to take a roll call on the bill as amended. The Vice Chair? Yes. Yes. Delegate Munoz? No. No. Crutchfield? Yes. Yes. Cardin? Yes. Yes. Bartlett? Is excused. Embry? Yes. Yes. Pasteur? Yes. Yes. Tolles? Yes. Schmidt? No. No. Simmons is excused. Boucher? No. Phillips? Yes. Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young is excused. Valentine? No. Conaway? Yes. Kaufman? Yes. Yes. Williams?
Yes.
Yes. 6, 7, 8, 9. That's 12. Favorable motion is adopted. Okay. Now we're going to Delegate Cardin's bill, right? I think. House Bill 427. There are no amendments? No amendments. Motion for a favorable? Okay. There are no amendments. Motions for a favorable. Discussion on the bill. I think they got this into a place where everybody is on board, so that's where we are with it. All right. Comments, questions, Delegate Tolles?
I'm sorry, can we just give a quick recap real quick? I'm sorry. 2 seconds.
So the Good Samaritan law basically says that somebody who calls 911 should not be under the possible prosecution for minor criminal offenses based on, for example, possession of controlled dangerous substance or trespass. And this bill would simply include the victim into that, so that a person shouldn't feel scared to call 911 because they're afraid the victim who's overdosing is going to somehow get arrested. That's all it does.
Any questions, statements? Seeing none. The Vice Chair? Yes. Munoz?
Yes.
Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Is excused. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young is excused. Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right, that's unanimously favorable. We are going to come back tomorrow with a voting session. I am anticipating that we're going to be in between sessions tomorrow. We may have 2 sessions. It's unclear at this point what we're going to be looking at, but we will be definitely voting tomorrow after the first session. And we thank you very much. That brings us to the end of the voting session for the House Judiciary Committee. Thank you.